We're here in cause number 19-32623, and we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. First of all, sir, you're Dalvius Williams.
Yes, ma'am.
And Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that that was true. And do you want to continue to plead true to that count?
Yes, ma'am.
Okay. And then count 2 alleges that you're behind in your court-assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count?
Yes, ma'am.
You want to change your plea not true?
Yes, ma'am.
Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses, Judge.
Okay.
They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
Knocking on the front door, so we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's
Yes.
been, oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 2. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that?
Yes, ma'am.
Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were, and all of that this morning. Is that correct as well?
Correct, Your
Okay.
Honor.
What if any offers? I want to make sure Mr. Williams, on the record, rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case, and the 4 is off the table in this case.
Okay.
I apologize, Judge, I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance? And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked? Did you say that?
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand?
Yes, ma'am.
Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right?
Yes, ma'am.
And so what do you want to do?
To first, but not to the injury to the child.
Okay, then we'll go forward with this hearing. So I want to make sure also for the record, what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. It starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes, ma'am.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016, burglary of a vehicle, 30 days jail, and then 2019, a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, The probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another new offense from January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he...
All right, so hold on. You're Dalvius Williams, and this is 25 DCCR 0176. Mr. Williams is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
Your Honor, Mr. Williams, and I filed the motion in this case after I explained and sent Mr. Williams a communication explaining what he was subject to in terms of punishment and what the state has indicated their enhanced punishment range and a motion to accumulate coming on a jury trial. He immediately told me he did not want me to represent him because I don't show his best interest. He would like to fire me, so.
You're court appointed, right?
Yes, Your Honor.
You don't get to fire your court appointed lawyer. You can fire someone you hire. Mr. Wilkerson is an excellent attorney. He handles many cases for all of us here in Jefferson County. If he's advising you of whatever your situation is, then your situation is what it is. So we can go through and what you're charged with and make sure we're all on the same. I feel like we've done that before because we've already had a plea bargain rejection, but let's do it again. It looks like you're charged, it's a third-degree felony, which means the punishment range is between 2 years and up to 10 years. However, it looks like, has there been, I don't see a notice filed of extraneous, but are there some that you
Yes.
anticipate filing?
Yes, Your Honor.
Mr. Smith?
Yes, Judge.
Two prior state
There's-
judges.
Well, there's a third degree, excuse me, Judge.
Hold on just a second while they get this figured out, and then I'll let you ask any questions you have, okay?
No, come with me.
So Judge, there's a state jail for criminally negligent homicide. There's another state jail for attempting to take a weapon. And then there's the third degree that Mr. Smith mentioned. There are no other TDCJ convictions.
So the third-degree felony conviction, if true, would enhance your punishment in this case, if you were found guilty, to the second-degree range of punishment, which is between 2 years and up to 20 years. Do you understand that? Okay. And it looks like we previously did a plea bargain rejection, and at that time, the third-degree felony was checked off instead of the second-degree admonishment. But I do want to make sure you understand today that if you go to trial, and if that conviction for the third-degree felony, the state jails don't enhance you, but the third degree would to a second-degree felony range of punishment. It looks like that rejection was for a 4-year term in prison. Is that still the offer?
That was the offer as of this morning.
Okay, so the offer is for 4 years in prison. You already said that you didn't want that. If you want to change your mind after discussing your options with Mr. Wilkerson, then we can take care of that. If you don't, then we'll set your case for trial. Mr. Wilkerson will prepare for trial, and we'll get it taken care of as quickly as possible. Yes, sir.
There was one more thing. The state had indicated an intent to file a motion to accumulate he just had an 8-year sentence on an
If
MTRP.
you recall, Judge, we had a motion, a contested motion to revoke probation with this as the allegation. We proved that up. You gave him an 8-year sentence.
Okay.
So that 4-year sentence that we had offered today was to run concurrently with that.
Okay,
If he rejects that, then we will file a motion to stack whatever he receives from the jury in this case on that 8 years that he's already served.
so I want you to understand, so the third degree conviction, is that something other than the conviction? The revocation, or that's the one that,
The revocation was for a injury to a, no, that was,
the prior conviction that y'all are talking about, that third degree,
That's on the MTRP,
that's on the MTRP?
yes.
And so, does everyone agree that timing, though, the conviction of that,
I see what you're saying. I don't think that one does, but I think the 2 state jail felonies bump it up to a 2.
they don't do anything? State jails don't do anything to a TDC case. And if I convicted him on an MTRP after this offense date, then he wasn't convicted on the offense date, and so that doesn't make it sequential. Am I right?
I think you are right, Judge, so I do think it goes to the,
I don't disagree that there could potentially be a cumulative request, but I don't think it would enhance his punishment, because I think it has to be a prior felony conviction before the date of this offense. Help me out, am I right?
I
I'm
think
looking at all the lawyers, everybody?
I think
Yeah.
you are, Judge. Yeah.
Okay, so forget everything we just said. The range of punishments between 2 years and up to 10 years in your case. State's offered 4. You can take your 4, you can go to trial. Mr. Wilkerson will remain your attorney. So what do you,
I want to go to trial.
okay.
And I want to see what is the outcome if I can get my own lawyer.
Well, yeah, so you have the right to hire your own lawyer at any time. But because you're in custody, we're going to move forward with your case. I'm clearly going to appoint you someone. You're not just going to sit in jail without a lawyer. We're going to make sure you have representation, and your case is going to move along. So if your family or you has the funds to go hire someone, then by all means, you need to get them hired,
Yes, ma'am.
and they can substitute in, and they need to get ready for trial also.
Yes, ma'am.
Until or if that happens, if it doesn't, we're going forward, case will be on the trial docket, we're gonna move forward. We're not gonna keep putting it off for that to happen.
Yes, ma'am.
If it happens, great, but as of right now, you're rejecting the 4. I also wanna make sure you understand, Mr. Smith, is there any reason to believe that that offer of 4 would change?
No, Judge, and in fact, we had offered to dismiss the case against the co-defendant in this case for his plea in this case to run concurrently with the time he's already served. In fact, it would be for less time, so.
Okay, so I do wanna make sure you understand that there's not gonna be any new offers. It's the offer remains what it is, no matter who your lawyer is.
Yes, ma'am.
And that there is the potential for anything you get from a jury to be stacked on top of that 8 years that you already got.
And that's it. That was the moment. The line where everything could have gone one way. And instead, went the other. He had the information. He had the warning. He even had a deal sitting right in front of him. But decisions like this aren't always about logic. Sometimes, they're about ego. Sometimes, they're about mistrust. And sometimes, they're about not understanding just how serious things really are. Now the case moves forward. No safety net. No guarantees. Just a jury, and consequences that could be a lot heavier than 4 years. And moments like this, they don't feel big when you're in them, but they change everything after.